Thank you, Chair. We are ready to proceed. However, I just want to place on record that there has been parties involved in threats and counter-threats. Both are parties to this tribunal, but I don't think it's necessary for us to go into the details. There has been a criminal case has been opened with SAPS, and they are investigating it. So I'm just informing the tribunal that there has been threats and counter-threats, notifying you, but I don't think it's necessary for us to go into details of those threats.
Yes, to put it more accurately, as we received it, there are allegations of threats and counter-threats.
That is correct, Chair. And then there was just a preliminary factor that needed to be dealt with. There's a question whether or not the complainant's legal representatives are allowed to ask questions and cross-examine witnesses, and the Chair indicated that a ruling will be made today on that.
Yes, there's been some indication from the respondents with our representatives that they are not comfortable with us.
That is correct,
I don't know whether the person who requested that person to actually give us the thing that we have to make a ruling.
Second, Chair?
I don't know whether there is persistence by anybody, especially as a contender, whether they want to cross-examine the respondent and the respondent's witnesses. A thing which is being opposed by the respondents with our representatives. Is there persistence with that request for the matter? Now, we have noted that the respondents with our representatives do not want that. Do we have to make a ruling? Or you have to simply persist and we have to make a ruling to that?
Oh, I understand. Chair, we persist in our request to be allowed to question any witnesses that appear before this tribunal.
In terms of interview?
In terms of the Act, which allows this tribunal to govern its own process, determine its own process, and also in terms of a precedent that has been set in judicial conduct tribunal hearings, such as the Flope hearing. There's a ruling of the Flope hearing in which this specific issue is dealt with. I'm afraid I only found it last night, and I don't have copies, but I can make that available. And in that ruling, it specifically says, at paragraph 60, I have it in front of me, that as for the participation of counsel for the justices of the Constitutional Court in the tribunal, suffice it to say this: those whom they represent are complainants. Their participation and them being represented by counsel has been accepted since 2009. The ruling goes on. I'm happy to make it available to the tribunal and to my colleagues, and I apologize for not having copies of it. But Chair, I would submit that the practice has been developed in this tribunal to allow complainants' representatives to question witnesses. It would be extraordinary, I would submit, to preclude us from questioning the respondents' witnesses. But of course, it's for this tribunal to determine its process, and we will of course follow your ruling in that regard.
You see, we looked at this situation. You see, the Act says the respondent is entitled to be legally represented, but it does not say the respondent is entitled. Sorry, it does not say the complainant is entitled to legal representation. We allowed that, but yes, it became in the sense of discussion. The rule gives the respondent the right to cross-examine witnesses for the complainant, but they don't give the complainant the right to cross-examine the respondent and respondent's witnesses. The rules don't provide. So why should we do that? Maybe you might want to, if you want to make a more formal application, you'll have to do that. If the attitude is also still that they are not comfortable with the complainant cross-examining the respondent.
Yes, Chair.
Rule 7 only gives the respondent the right to cross-examine witnesses, but not the complainant. It says it is the leader of evidence who should cross-examine the complainant, the respondent and the respondent's witnesses. So if you want to do that, you have to show us the and the basic. And then, I guess, and I guess you had me. So both counsel must prepare that sort of thing. So that's only.
Can I just make 100% sure that I understand you correctly, Chair? Should we wish to question the respondent's witnesses, we would need to make a formal application to do so.
Yes, because in terms of the rules, we are not entitled.
Yes, and would the tribunal require formal written application, not an application from me on my feet, for example? No.
I don't know whichever you think is best. Right? Just Victoria is suggesting that you have to do that, even with the rates of argument. But when you're going to do that, you need to ask for that.
Yes, we will certainly do that, and we will. I'm so sorry, the mics appear to be going on and off, but we will certainly make a formal written application. We'll try and do it so that as soon as proceedings are finished today, we will work on that and try and get that to our opponents and the tribunal as soon as we can tonight.
Yes. For us not to hear from Advocate Secretary. Yes, we will wait for the approach. Thank you.